So let's start our program. Okay, so let me introduce first. Our speaker for today. Ayan. So our guest speaker is a graduate of BS Architecture at La Consolacion College, School of Architecture, Fine Arts and Interior Design in Bacolod City. He passed the licensure examination in June 1998 and took his oath before the Professional Regulation Commission in August 10, 1998. Yeah. His expertise is architecture. In architecture has led him to focus on the following: residential and small-scale commercial establishment designs, construction contracts, drafting and review, construction claims management and administration, construction quantity surveying, construction arbitration, technical counsel, construction arbitration, and other alternative modes of dispute and resolution. So he is formerly served as an employee of one of the local government unit in Negros Occidental. Our guest speaker was also a former overseas Filipino worker in Dubai, where he was employed as an architect coordinator and quality control and quality assurance architect, and was later assigned as an assistant construction contracts administrator of Ogre, Dubai. He formally joined the Academia de la Salle das Marinas, Technological Institute of the Philippines, and Central Colleges of the Philippines. He was also formerly a lecturer at the Brown House Studio Architecture, Atelier Center for Architecture and Workshop, and a professorial lecturer in construction contracts and claims management in a number of construction companies in National Capital Region. He was formerly an employee of Santa Clara International Corporation as a contract administrator, a former contract manager of Ryder Levitt Bucknell Philippines, and as vice president of contracts and project management of YEC International Engineering Services. He serves recently as the contracts manager of Megawide Construction Corporation. At present, his firm is engaged in private practice in the field of architecture, specializes in different modes of alternative disputes resolution as construction, contracts and claims management, commercial arbitration and mediation, and construction arbitration. He further advanced his studies in project and contracts management in Dubai, UAE, and at the University of the Philippines National Engineering Center. He completed his degrees of Juris Doctor at Philippine Law School in 2018 and completed his academic training in commercial arbitration at Philippine Dispute Resolution Center Incorporated in 2016 and construction arbitration at the Construction Industry Arbitration Commission, CIAC, this year, 2019. He took his oath of office as accredited construction arbitrator of the Construction Industry Arbitration Commission before Justice Lucas Bersamin of Supreme Court of the Philippines on August 8, 2019. In 2008, he published a book, The Essentials of the Practice of Architecture, and in 2019, he published another book, which is RA 9266, The Architecture Act of 2004, Q&A with Notes and Cases. Yan, both are available at Central Bookstore nationwide. Also, meron din siyang recently published book. Ang title is Understanding RA 9266 in the Most Pragmatic Way of Discussion with Notes, Cases, and Jurisprudence. Ayan. So, our lecturer for today, our speaker, architect, arbitrator, Alfredo Fernandez, Juris Doctor. So, ayan. Let's welcome naman architect Alfredo. Maestro. Ayan, ang tawag sa kanya is Maestro. Hello, Maestro.
Hello, good afternoon to all, and thank you for inviting me to this event. No? And well, my topic for today is not about RA 9266. No? Kasi when I was invited, Sarena wanted me to discuss RA 9266 in relation to COVID-19. Parang sabi ko parang hirap i-explain or i-discuss ang RA 9266 in relation to COVID-19. And we choose the topic variation orders because ang focus natin is how pandemic or the COVID-19 affects construction contracts. No? Kasi yun talaga ang nagiging problema ng mga construction industry ngayon. Hindi nakapagbalik ng construction works because of the effect of this COVID-19. But before that, we will discuss first what are the principles and practices in construction contracts administration with regards to the practice on the variation orders.
Yes, sir. So, yes, sir. I-share niyo lang, sir, yung screen niyo ng PowerPoint.
Yes.
Share screen. Okay ba?
Okay, so the topic for this afternoon is about variation orders. I think yung topic natin is talagang gamit na gamit ng mga architects, na lalo na yung mga nagpa-practice na belong sa contractor side or in the design and build services. Malaki ang role ng isang architect sa variation orders, especially doon sa approving ng mga request for information, no, as to conflict of design, discrepancies in the design, discrepancies in the design specifications, no, discrepancies in the contract documents. So malaki ang role ng architect, and later on titingnan natin kung ano yung system na nawawala sa practice na hindi nabibigyan ng pansin ng ating mga architects acting as project managers with the owner or acting as the architect of the owner in behalf of the owner pag walang hired na project management or construction management team. At the same time, pag ikaw ay architect who belong to the contractor side, malaking bagay din itong variation orders dahil these variation orders usually is the element of disputes in arbitration cases. No? Dito palagi nagtatalo ang mga owner and contractor, no? Contractor and the architect acting as project manager of the owner. So maganda itong topic, no? Hindi lang tayo relating sa design, but of course in the administration of the contract works pagdating sa ating construction projects. But before that, I want to give to you this chart, no, for you to familiarize what happens in the construction contracts administration. I know marami siguro yung mga young architects, no, na belong sa mga contractor side, or in their diversified training, they belong in the contractor side and not on the owner side, or not practicing project management. No? So this chart will explain on what is the process of construction contracts administration and management. So usually, if you can see on the chart, I started with the issuance of the letter of award and the notice to proceed. But generally, the first thing that happens during construction contracts administration is that from the start is the bidding and tendering process and procedure, which usually that is called as pre-construction contract. And this chart belongs to construction contracting. Dahil dito pumapasok ang ating tinatawag na variation orders. So what happens usually after the tendering works, after the bidding, no, the owner will award the construction contract to any contractor who won the bidding, and then the first thing that the owner or the owner's architect in his behalf or the project manager should issue a letter of award and a notice to proceed. Generally, the notice of award and the notice to proceed is not really as in the same document, but they are practitioners in the quantity surveying industry and project management industry na nag-i-issue sila ng letter of award at the same time iisa lang yung document with the notice to proceed. But generally, pwedeng mauna yung letter of award, pwedeng mahuli ang notice to proceed. Dahil of course, hindi naman necessary na pag nag-issue ng letter of award, the contractor has to commence the work. Kasi may mga problema rin minsan yung owner that some of the lot kung saan ipapatayo yung project is meron pang mga illegal settlers and hindi pa napaalis, for example. So the owner may issue a letter of award and later on, saka pa lang siya mag-issue ng notice to proceed. But there were cases that the owner or the owner's representative issue a notice of award at the same time with the notice to proceed kung talagang ready naman yung site na magkaroon na ng construction works. No? So doon ngayon papasok ang commencement of the work ng isang contractor. Ngayon, kung ikaw ay the owner's representative as an architect, walang project manager. So, ikaw yung mag-i-issue ngayon ng notice of award or letter of award and notice to proceed. Ang critical areas sa pag-issue ng notice of award and letter of award and notice to proceed is that you have to be sure that the construction site is ready for the contractor to commence the work or to mobilize the work. Otherwise, it will trigger of a variation order at the early stage of this award of the contract. Example, nag-issue ka ng letter of award and notice to proceed, and the contractor now compute the running of the period of their number of calendar days under the contract, but the site is not yet ready for the contractor to commence the work, to mobilize the work. Then si contractor usually at the early stage pa lang magki-claim na sa iyo ng extension of time element, no? Dahil of course kakain ng kanilang calendar days. Pagdating sa dulo, pag kinain yung completion date, the contractor will be penalized of liquidated damages. That is the effect of that contract to the contractor. So si contractor at the early stage, magki-claim na siya ng extension of time if the site is not ready, the contractor was not able to get the site for the commencement of the work. So critical areas ang pag-issue rin ng letter of award and notice to proceed. So with the issuance of letter of award and notice to proceed, the contractor now will perform its obligation under the contract dahil tatakbo na ang kanyang day 1 of commencement date. Now, in the contract, walang problema pagka malinaw na nakalagay ang day 1 ng contractor. The question is, paano pagka hindi na-specify sa pag-issue ng letter of award or notice to proceed kung kailan ang day 1 ng isang contractor? So, the practice in the industry is that upon receipt of that letter of award or notice to proceed, the contractor has the 7 days to commence the work. So ang nagiging day 1 na contractor usually in industry practice pagka silent ang letter of award and notice to proceed is that within 7 days from that receipt of notice, that counts the day 1 of the contractor. But generally, meron namang program no, na sinasubmit ang winning bidder, no, and nakalagay doon sa program usually kung saan yung day 1 and computing the number of calendar days up to completion of the project. So the compliances to that issuance of letter of award and notice to proceed, doon na ngayon si contractor mag-comply ng kanyang performance bond, surety bond, and yung contractor's all risk insurance, no? Kasi usually nagiging requirements yan sa pag-release sa kay contractor ng kanyang advance payment. Okay? So pag walang compliance, then wala ring advance payment na marirelease sa kay contractor. Now, there were some contract that provides that the commencement date of the contractor shall be on the issuance of the building permit. The question ngayon is, kaninong responsibility ang processing ng building permit? Now, if you are on the owner side and the owner is the one who will process the building permit application, better not to issue the letter of award or notice to proceed pagka wala pang building permit approval. Kasi yung contractor usually, magka-count pa rin sila ng kanilang calendar days doon sa issuance of the building permit application. But if it is the requirement of the contractor to process the building permit needed for the project, then let the contractor work for it as long that it was awarded to the contractor, whatever day one or calendar days that was awarded to the contractor, then it will count the day one of the contractor. As long that it is clear in the contract na talagang yung day one niya, regardless of the release of building permit, will count. No? Kasi may mga kontrata rin na kahit yung contractor na nagpo-process ng building permit, still nakalagay doon that the counting of the day one of the contractor is on the release of the building permit. Ang nagiging problema palagi dyan is that nobody from those contractors, no, or some other architects hindi nagre-review ng provisions ng kontrata, no? Sa general conditions minsan nakatago yung mga item that will trigger for an additional cost to the owner pagka nag-claim si contractor. So kung ikaw is architect and you are the advisor of the owner, see to it that it is clear for the owner na malimit ang pag-charge sa kanya ng contractor ng claims for either extensions of time or claim for an amount of money. No? Kasi hindi lang tayo nagdo-drawing, hindi lang tayo nagbibigay ng design sa owner, but being a consultant of the owner, mayroon kaakibat na money involved yon, and that is our responsibility to limit yung financial cost na magiging burden sa owner later on pagka nakuha na ng contractor yung project. So, access to the site, the contractor will access the site, and then when the contractor has access to the site and they will perform the obligations under the contract, then that's the time on that commencement date to the completion date, doon ngayon usually nag-trigger ang lahat ng issues, no, that will resort to a claim for a variation orders. Napakalaki yung role ng architect dito sa variation orders. Bakit? Ang kadalasan na nangyayari is that if there is an incompleteness of the design, there is an incompleteness of the details of the work of the contractor sa kanyang for construction drawings, that also triggers for an additional cost to the owner para bayaran si contractor. Dahil sinasabi palagi ng contractor, ang aking kontrata is only within the bounds and the parameters of the issued for construction drawings and those drawings provided during the tendering of the works during the bidding period. So pagka may lumabas na ibang detalye na wala doon sa bidding time, magki-claim ngayon si contractor ng additional cost. Itong palaging nangyayari. There is a design from the architect during the bidding period na hindi kompleto, no? And let the contractor or let the bidder submit their bid based on that drawings issued during the tendering stage. Pagdating doon sa construction stage, doon ngayon nag-i-issue si architect, no, ng mga additional details, additional drawings, at ang tawag natin doon is construction bulletin, no? So mas maigi na yung mga details na kailangan to complete the drawings, no, to be supplied to the contractor as a construction drawings, dapat during the period of the tendering stage, the bidding stage, dapat doon ka na mag-issue ng bid bulletins. Huwag ka na mag-issue dapat ng construction bulletins during the construction work, no? Kasi yung mga construction bulletins, although sometimes it will just interpret doon sa mga kailangan i-detalye, pero ang mga reasons ng contractor usually is that hindi ho yan na-consider during bid, no? And malaki yung cost implication. So kung hindi malinaw ang variation clause, magiging additional cost sa part ng owner. And baka mamaya ibalik sa architect, no? Ang sasabihin ng owner, architect, sandali, kulang daw ang iyong detalye sa design, kaya hindi daw yan na lagyan ng cost ng contractor and they are claiming for this much, no? Eh ang ating architect's fee, no, magkano lang yan pagdating sa kliyente. Pag sinabi ng kliyente, architect, i-charge ko to sa iyo dahil kulang ang iyong detalye, saan kukunin yan ng isang architect to cover, no, ng expenses. No? Kaya ang architect's fee natin is only limited on the percentage, but the cost of the work na gagawin ni contractor later on, mas malaki, no? Mas triple doon sa ating architect's fee. Okay? So, in this chart, pag nakita natin, there is a commencement date, and with that, meron tayong issues and specifications, no? Contractor cost problems, pending change orders, and then completion date. Okay? So mga issues na yan, normal na nangyayari. Minsan nagkakaroon ng mga defective and deficient contract documents. Nagkakaroon ng differing site conditions, no? Hindi natingnan yung underground soil. Nung maghukay si contractor is iba yung subsurface condition. No? Kaya dapat malinaw din sa boring test na tama yung mga nadidistinguish nila doon sa ilalim ng lupa. No? Para yung costing ng contractor sa mga allowances nila is accurate din or sufficient to cover the contingencies or the allowances. Okay? And then, acceleration, no, and other issues na mag-come up during the performance of the work from the commencement up to completion of the project. So I emphasizes that the variation order should be from the commencement of the work up to the completion of the project. Later on, makikita natin bakit pagka lampas na ba ng completion date, wala nang variation orders. Makikita natin sa series of discussions natin na tuloy-tuloy. Okay, never mind yung mga clause na nakalagay because that clause that was based on other contracts na ginamit ko noon sa isang discussion. But some clauses today, we will use the CIAP 102 because that is the conditions of contract that was used as industry practice, no, sa Philippines. Even the Supreme Court uses that CIAP 102 as reference in the industry practice. Okay, so what is really a variation? Okay, so variation is in the context of construction, dalawa ang kanyang meaning. Okay, a variation is a change to the contract or terms, and the narrower meaning is that it is a physical variation or change to the work, either quantity or quality required. Okay, so terms in the contract, nagbago kayo ng agreement, it will trigger for a variation. Pag nagkaroon ng changes in the plans, changes in the specifications, that will trigger to a variation. So ang palaging critical issues dito is that dapat naaral din ng isang architect yung kanyang design or kanyang project before it will be executed, no? Kasi pwedeng magkakaroon ng increase, pwedeng magkakaroon ng decrease to the cost of the work depending on the changes that the owner will order, or either the architect will value engineer, no? Kasi pag nag-value engineer, there is a changes in the cost, either deductive or either an additive variation. So at the early stage of the planning ng isang architect, before it will be out for the bidding, dapat naaral na rin yung mga possible changes, yung mga possible value engineering, no? Para later on, alam ng owner kung paano nyo babudgetan pag nagkaroon ng changes to the work, changes in design, changes in the specifications. Okay? Next, variation in construction contracts are the one of the most common causes of disputes between the parties. Such disputes often revolve around the following issues. Itong palaging tanong doon, was the work in question within or outside the scope of work? No? Kasi makikita naman sa scope of works, pero minsan hindi malinaw yung scope of works. Kasi ang basis nila minsan ng scope of works is only those listed in the bills of quantities. But there were provisions in the bills of quantities, or there were provisions in the contract or the instruction to bidders sometimes that sinasabi ng mga quantity surveyors and the project managers that the bills of quantities is only for purposes of measuring the accomplishment of the contractor and not really the completeness of the scope of works. Mayroong mga ibang consultant na sinasabi nila that gumagawa kami ng bills of quantities, but the contractor has the authority to scrutinize the completeness of the drawings and specifications. At kung wala doon sa bills of quantities, dapat i-include ni contractor sa kanyang bid and ilagay niya doon sa others. Otherwise, the consultant, no, the architect, as a consultant of the owner, will consider that other works not included in the bills of quantities na scope of works as included in other areas. No? So kailangan linaw yung mga provisions. Otherwise, magkakaroon ng problema and will trigger for a variation orders. Number 2, did the parties comply with the procedural requirements under the contract regarding directing and claiming for a variation? Meron kasing procedural order, no, ang pag-claim ng variation, and usually there were technicalities minsan, no, na nagreklamo yung contractor dahil hindi na-grant ang kanyang variation order na tama ang variation, no, it really a variation, pero by technicalities hindi niya nakiklaim because hindi niya na-comply yung requirements. Example, yung time to claim for a variation, nag-lapse na yung period, no? Although valid ang kanyang claim for variation, but because of that timeliness ng pag-submit ng kanyang notice of claim, for example, hindi na siya pwedeng mag-claim sa owner. So that was sometimes one causes, no, nag-trigger ng arbitration case, no, dahil hindi na approve yung claim ng isang contractor. And number 3, what is fair or reasonable value of the variation work? How this variation works will be paid, how this variation works will be measured. Ito ang palagi kong nakikita when I was in the contractor side, no? Yung owner or the architect usually issued drawings, specifications, bills of quantities, pero hindi na ipoprovide ang tinatawag nating rules for measurement. Mayroon tayong tinatawag na rules for measurement sa bid documents. And that rules for measurement is the basis on how the contractor, how the consultant will measure the quantity of the work, and how the consultants will cost the scope of works, no, given in the contract. So minsan wala yung rules for measurement, no, and the contractor, yung mga quantity surveyors nila, hindi rin nagre-raise ng question na walang rules for measurement and paano natin i-cost itong project, no? Pero nagdi-derive sila doon sa normal estimating, direct estimating, okay? Pero may mga consultants naman na talagang nagpo-provide ng rules for measurement, like for example, yung POMI, no? Yung RLB, meron din silang rules for measurement. Yung Arcades, meron din silang rules for measurement. Minsan nawawala yan sa bid documents at hindi hinahanap ng mga nagbi-bid out. And later on, nagkakaroon sila ng conflicting opinion pag reconcile sa cost, no? Hindi sila magkakaintindihan ng reconciliation sa cost dahil iba yung method na pag-estimate ng contractor, iba yung method na pag-estimate ng owner or owner's representative. So napaka-importanting bagay ang completeness ng bid documents during the period of bidding, at the same time during construction works. Kasi kung may mga extra works, yun lang yung magiging tools para magkakaroon kayo ng apple to apple sa inyong costing. So napaka-importante yung rules for measurement, at the same time kasama diyan yung tinatawag na trade preambles. Okay? Okay, given the issues which may arise in relation to variations, the mere performance of extras or variations may not necessarily give rise to the principal having a liability to pay for such work. Generally, the contractor will have to demonstrate that the owner should pay and the work is outside of the contract. So hindi lahat ng extra, hindi lahat ng outside the scope is claimable to the owner. Kaya meron tayong sinasabing you have to claim for this period for the owner to assess. And at the same time, in that period of submitting your notice of claim, you have to submit substantiate under the contract. You have to provide the clause in the contract. You have to provide all the details in the plans, the specifications, comparing the bid documents and construction documents. That emphasizes that that scope of works is really an extras and not part of the scope of works of the contractor. Otherwise, the contractor cannot claim for an extras if he cannot provide the details of such ambiguities on the issued plans and specifications. Okay. Mayroong procedural requirements under the Civil Code. Although, majority of the contracts, mayroon namang nakalagay na procedure, no? The notice of claim, the timeline for substantiating a claim, no? Meron naman sa kontrata minsan. But how about if the contract is silent? Okay? So if the contract is silent, there is a variation clause under the Civil Code. So under the Civil Code, under Article 1724, ito ang sinasabi para makapag-claim ka ng variation orders. Sabi ng Article 1724, the contractor who undertakes to build a structure or any other work stipulated for a stipulated price in conformity with plans and specifications agreed upon with the landowner can neither withdraw from the contract nor demand an increase in the price on account of the higher cost of labor or materials, save when there has been a change in the plans and specifications provided. Ang unang requirements is that such changes has been authorized by the proprietor in writing. So yung changes na yan dapat approved ng owner, not the owner's representative lang. It should be approved by the owner. Kasi maraming mga practitioners sa project management firm na sila yung nag-a-approve without a document approved by the owner. Okay? So, ang question is, does that project management firm has the power and authority to approve variation? Okay? Number two, the additional price to be paid to the contractor has been determined in writing by both parties. Napag-usapan na yung presyo before the contractor shall execute the variation works. Marami sa industry. Well, yung mga contractor minsan hirap, no? And kahit hindi reconcile yung cost, as long na may PMI, no, may project manager's instruction, the contractor perform the variation works in the construction site. But you know, may problema dyan, no? Kasi may pinangahawakan kang project manager's instruction. Ibig sabihin, you comply with the number one, no, the authority from the proprietor in writing, then may project manager's instruction, but there is no compliance with the price kung paano ka babayaran at magkano yung ibabayad sa iyo, no? Walang reconciliation approved between the contractor and the owner or the owner's representative, for example, like the architect. Pag wala yung number two, pwede kang hindi bayaran because there is a lack of procedural requirements under the law, no? So napaka-importante yung mga procedural requirements na yan kasi technicalities, pagdating mo doon sa arbitration, dahil na technical ka, you cannot really claim, no, mababard ka. So napaka-importante ng technicalities and procedural requirements under the contract or under the civil code. Okay, if there is a contract, well, the contract will prevail because that is the law between the parties, no, between the contractor and the owner. Pag wala, babalik tayo dito sa Article 1724 ng Civil Code to comply. So, for the contractor, dapat before you act on site, before you perform the extra work or the variation works, you have to see to it that the cost has been reconciled and agreed in writing between the owner or the owner's representative and with the contractor. Otherwise, later on, no, sasabihin mo magiging leverage mo yan, pero baka mamaya matalo ka pagdating sa arbitration, no, because you did not comply with what the contract says and what the law provides with regards to variation orders. So napaka-importante ang variation orders. Okay. A variation is a change to the work, quantity or quality required to be carried out under the contract. It is essential to be able to clearly identify the work the contractor is required to perform under the contract in order to determine if there has been a change and the extent of that changes. Okay? Madalang sa mga contractor din minsan na nag-compare ng bid plans and construction plans. Okay? So, minsan, ang nagiging problema, huli na, no? Saka sila titingin doon sa bid plans. But generally, what my advice usually sa mga contractors seeking may advice, may consultancy, is that at the early stage of the commencement of the work, the engineering team should see to it na nabangga nila yung issued bid documents and construction documents. Kasi in that stage pa lang, at the early commencement of the work, dapat nakita na kung ano yung mga difference between the issued bid documents and the issued construction documents. Whatever deviation from that bid documents, you have to check with the contract kung considered as variation order. Okay? Ngayon, meron tayong tinatawag na sinasabi natin variation order, change order. Ano yung pagkakaiba nun? Usually, it's the same, no? Variation order usually used in the UK, and change order is used in the US, no? It's American principle word na ginagamit nila doon. But there is a concept on that variation and change order. Ang tinitingnan is that usually the architect or the owner's representative, no, if there is a changes in the work, halimbawa si contractor yung nag-request or si architect din ang mag-request that there will be changes in the work, the architect or the contractor will submit a request for a change. And that request for a change shall be submitted to the owner for approval. Okay? So that request for a change, once approved by the owner, that will become a change order from the owner's side. Okay? So the owner will approve that, and that will become a change order, and that change order will be given to the owner's representative. Pag binigay yan ng owner's representative sa contractor, yun na ngayon ang tinatawag natin project manager's instruction or architect's instruction. So doon sa project manager's instruction or architect's instruction, dapat naka-attach yung request for change, no, or request to varied works, no, para doon makikita yung perma ng owner attached to that project management instruction or project manager's instruction issued by the owner's representative to the contractor. Kasi doon makikita ngayon yung authority that the power to varied works came from the owner and not came from the owner's representative alone. Napaka-importante yung authority to varied works. Then that will be called a variation to the works because there will be now a variation to the cost of the contractor and variation to the contract of the contractor. So napaka-importante yung principle ng changes to the work as approved by the owner. The contractor's activities is defined as all things or tasks which the contractor is or may be required to do to comply with its contract obligation. But of course, usually ang contract obligation ni contractor is only limited to what has been submitted during the bidding, no? What has been defined under the contract. Pagka labas sa contract, hindi yon part ng contractor's activities. Take note, mayroon kaming tinatawag na pinag-uusapan kasi natin is variation order or change order. But you know, ang change order usually, it should be incidental to the original work by the contractor. So, if there is a work that needs to be deviated from the original drawings, no, nagbago, pero part siya ng original scope, then that is a change order or variation order. If that scope of work is not really defined in the contract, not part of the scope of the contractor, tapos dagdag lang nagdagdag si owner, that is what we call additional order. So magkakaiba yung change order or variation order doon sa tinatawag naming additional order. Although, yung mga practitioners, no, yung mga project management firm, no, quantity surveying firm, hindi yan sila gumagamit ng word na additional order, no? Usually yung ginagamit nila kahit extra work na, kahit additional work na, still they consider it as variation or change order, and they are not using the term additional order. But the correct term there is additional order pagka outside the original scope of works of the contractor, and if it is not also an incidental to the original scope of work of the contractor. So take note of that. So let's see how some contract clauses defines the scope of works. Okay? So minsan sa kontrata makikita natin yung definition ng works that says means that the whole of the work to be executed in accordance with the contract, including all variations provided for by the contract, which the contract are to be handed over to the principal. So pag nabasa natin yung ganong clause, kung ikaw naman ay sa contractor side, ay dapat maalarma ka na, no? Kasi ang sinasabi, it is a lump sum contract na kahit pa may mga additional works by incidental works that is already covered on your contract, hindi ka pwedeng mag-claim, no? Kasi sinasabi doon, it already includes all variations provided for by the contract. So dapat nagre-review ng kontrata yung mga nasa contractor side, no? Even yung mga nagdi-design and build, kasi pwede yung owner. Although design and build ka to the owner, pero meron siyang lawyer or may third-party consultant siya to look into your work being a design and build architect. Okay? Another definition is that work under the contract means the work which the contractor is or may be required to execute under the contract and includes all variations. So, well, on the owner side, pag ikaw sa owner side, usually ito yung mga clauses na gagawin mo being an architect. Now, kasi you have to protect the interest of the owner na whatever additional works, whatever additional variation na mag-trigger, sasabihin mo doon dapat kasama na yan doon sa bid ni contractor. No? Well, kung si contractor naman is hindi nag-react during bidding, he cannot do it anymore during the construction works. No? Dahil kung na-award na sa kanya yung project, ibig sabihin, the contractor agree during that bidding pa lang na all the documents na sinubmit sa kanya is okay sa kanya and tinanggap niya yun. No? Kasi ang point natin dyan is that the conditions of contract should be reviewed at the same time during the bidding period and not during the award or the commencement of the work. Ang point natin dyan, dapat on the commencement of the work, magpipirmahan na lang dapat yung owner and the contractor or the architect and the contractor, and hindi na dapat nagre-review pa ng kontrata. Otherwise, mapiprejudice ang performance of the work, no? Dahil pag nagkataon, umaandar yung trabaho tapos nagtatalo-talo kayo, yun yung trabaho later on, magkakaroon ng stoppage of work or delay ang performance of the work dahil si contractor is may mga hinihinging kapalit doon sa kontrata, and you cannot enforce the contract dahil wala pa kayong pinirmahang kontrata. So the contract should be reviewed during the bidding period para pagka nag-award sa kanya, pirmahan na, and the contract will be enforceable with both parties during the performance of the work. Okay. Another clause is that the contract means all the documents which constitute or evidence the final and concluded agreement between the principal and the contractor. So once you signed with the contract, whatever defined, whatever enumerated in the contract as the scope of works of the contractor, then doon kayo iikot sa scope of works of the contractor. So whatever out of that scope of works of the contractor, then that will be considered as extras to which the contractor can claim for an additional cost to the owner. Ang problema dyan, yung extras, if that extras came out because of the lacking of details, no, walang sufficient design from the architect, kaya nag-trigger, babalik sa isang architect ang cost implication, no? Baka magalit sa atin si owner pag nagkataon. Okay? In the case of Barter versus Mayor of Melbourne, it is a UK English case kasi yung ating construction contracts nanggaling sa ibang bansa, ginaya lang naman, no? Wala tayong construction law sa Pilipinas. We are a civil law country. And yung UK, meron talaga silang construction law. Okay? And yung focus doon is only construction contracts. Sa atin, wala tayong construction law. we have only SIAC as arbitral body to resolve disputes relating to construction contracts. Pero wala tayong construction sa Pilipinas. So in the case of Barter versus Mayor of Melbourne, Chief Justice Stawell defined variations as works which are not contemplated by the parties at the time of the execution of the contract. So ibig sabihin talagang hindi yan pinag-usapan, hindi yan kasama nung time na nag-uusap tayo, nung time na nagbibid tayo, hindi yan kasama. Then that is considered as variation. Okay? Thus, the initial critical question is considering the subject of variations is whether or not the performance of an item or process of work is on a proper interpretation of the contract already included in the contractor's performance. So, kailangan define ang lahat ng scope of works, no, para wala na pagtatalunan pa during the time of the performance of the work. Dumadami lang naman yan dahil minsan hindi rin nagre-review yung contractor, submit lang na submit ng bid, and the architect is not also lenient sometimes to check, no, kung ano yung mga kulang. Take note, during bidding, example, or ikaw yung hinire ng owner as the representative of the owner, no? Ikaw yung nagpapabid. Dapat kung ano yung mga query ng lahat ng bidder should be relayed to all other bidders, no? Kasi later on kailangan apple to apple ang pag-assess ng bid ng each bidder. Kasi pwedeng merong nakita yung ibang bidder, hindi napansin ng ibang bidder. That information should be relayed to all bidders para later on kung sino man ang magkaroon ng award sa project, na consider ang lahat ng mga lapses na nakita ng ibang bidder na hindi napansin ng mga ibang architects or the owner's representative. Okay. Work not expressly included. The contractor not only has an obligation to complete the work as expressly described in the contract, but also other work which, although not described, is necessarily required. This is a common sense rule as aptly demonstrated in the open-quoted Williams versus Fitzmaurice case. Itong work not expressly included, maraming nagkakamali rin dito, no? Sinasabi nila not included, but actually it's included. Take note, mayroon akong experience na yung isang painting works, no? Isang painting works ng exit, yung fire exit ng isang mall. Walang detail ang exit stair na pipinturahan because that stair is existing, no? Hindi naman yung mall is existing and nag-renovate lang yung mall. So yung fire exit stair hindi nakadetalye at hindi nakalagay doon na pipinturahan kasi walang detalye, no? Ibig sabihin walang graphical presentation. But you know, there is a wordings in the general notes that all exit stairs shall be painted. Hindi napansin 'yon ng contractor. And the contractor is claiming for another cost. At sinasabi ng contractor, that is not expressly included in my contract. Wala sa BOQ. No? Wala sa Bills of Quantities. So, hindi ko yan na-costingan. Pero, nandoon sa general notes, mayroong kulatilya sa kontrata na baka hindi mo yan na-query at hindi mo yan nasabi before or na-clarified before, that is considered as included. And we will anticipate that that portion of that scope of works was inserted to any other scope of works in the bills of quantity. So walang nagawa yung contractor, no? It includes, nag-suffer siya ng costly. Ang laki ng fire exit, no? Ang project namin is yung Shangri-La Mall. No? 8 fire exit na malalaki. So nalugi yung contractor because that is from ground floor up to 5th floor. Okay, so ibig sabihin is that you have a common sense, no, na hindi naman dahil hindi nagkaroon ng graphical presentation hindi na siya kasama, no? Kasi napaka-importante basahin din ang general notes dahil nandoon yung mga maliliit na bagay, maliliit na wordings pero malaki ang cost implication pagdating sa owner. Let's see this case. Okay? The contractor undertook to build a house ang nakalagay sa kontrata is dry and fit for occupation. No? Dry and fit for occupation. So yung sinasabi natin na fit for the purpose. No? Na dapat pag tinurn over mo sa akin, matitirhan ko. No? So usually may mga ganong kontrata. The specifications noted floor joist. Itong kagandahan, nakalimutan yata ng architect na sabihin ang flooring. Ay sinasabi lang sa kontrata, sa specifications is that the specifications noted floor joist but failed to expressly mention flooring. Walang sahig. Okay? Floor joist lang. Then the contractor argued that the provisions of flooring constituted a variation. Sabi niya, additional cost yan kasi hindi described in the specifications, no? Hindi rin described in the plans. The contractor argued that the provisions of flooring constituted a variation. The court held that although flooring was not specifically mentioned, it was clearly to be inferred from the language of the specifications that the plaintiff was to do the flooring, and this was necessarily included in the obligation to complete a house dry and fit for occupation. So biruin mo yon, no? Nakalimutan, pero sabi ng korte, hindi, kasama yan because there is a wording fit for occupation. Paano mo naman matitirhan ang isang bahay na walang sahig? No, ganun lang naman ang kasimple sinabi ng korte, no, because of that word, dry and fit for occupation. So minsan, di ba, yung mga wordings, kailangan nating intindihin ng mabuti. No? Kasi it's only a single word, no, or double word. Pero napakalaki ng impact niya pagdating sa cost ng owner and pagdating sa cost ng contractor. Ibiruin mo kung malawak yung area, shoulder ni contractor dahil hindi niya nabigyan ng cost sa kanyang bid price. Shoulder niya ngayon ang cost ng flooring. So walang nagawa yung contractor but to do the work. No? Dahil otherwise magkakaroon siya ng breach of contract. Okay, inconsistencies in scope of works provision. Inconsistencies between the different parts of the relevant contract providing details of the work to be performed can provide the basis for a variation claim dispute. Kailangan, as architect, no, sa ating mga part, see to it that hindi magkakaroon ng discrepancy ang ating graphical presentation sa plano and yung ating specifications. Kasi pag nagkaroon ng discrepancy, ang specifications and yung drawings, magkakaroon din ng effect sa owner on the cost dahil magti-trigger din siya ng variation work. So may mga methods kung paano i-resolve ang mga inconsistencies ng between plans and specifications. In additional to contract provisions dealing with the resolution of any ambiguities, discrepancies, or inconsistencies in contracts, the common law has developed rules regarding the resolution of such issues. Some of these rules are as follows. Ito yung mga rules to settle ambiguities in the conflict of the discrepancies between plans, specifications, and other contract documents. Ito ay rules ng common law country like UK. But later on, babasahin ko rin yung rules na ginawa ng SIAC, no, yung SIAP, Construction Industry Authority of the Philippines. Meron din tayong rules sa SIAP 102 kung paano rin natin i-resolve ang mga ambiguities dito sa Pilipinas. I will just laying the principle first sa international kung ano ang pag-settle sa mga ambiguities. Then later on, we will discuss SIAP 102. So sinasabi doon sa common law country, the interpretation is to be determined objectively. That is, the ascertainment of the meaning which the document would convey to a reasonable person having all the background knowledge which would reasonably have been available to the parties in the situation in which they were at the time of the contract. So, palagi ko sinasabi sa mga nag-i-engage sa akin for consultancy, lalo na sa mga bidding, that dapat gumagawa ng tender report at the end of the bidding. Anong tender report at the end of the bidding? During the bidding period, dapat mayroong nagmi-minutes ng lahat ng bidding, ng discussions, no? Lahat ng submissions. And dapat nagagawa ng istorya, no? itong nangyari during the first stage of the bidding. Nag-invite ng bidders, nagpa-submit ng pre-qualification, hanggang doon sa qualifications, hanggang nag-award. Dapat ikikwento mo doon sa report mo kung anong nangyari. No? Ikikwento mo doon kung ano yung mga inquiry nila, how does inquiry was resolved. Kasi later on, ang nagiging dilemma ng mga nasa construction stage is that yung mga sumali doon sa bidding na nag-negotiate, wala na, nag-resign na. Okay? So wala nang magsasabi na ito yung pinag-usapan namin dahil wala ring minutes of the meeting, wala ring tender report, no? And the side of the owner, wala ring gumagawa, no? So nagiging unfair minsan, no, to both parties dahil nagtatalo na during the bidding is ganito daw, sabi ni ganito, sabi ni ganito. So lahat ng mga involved during construction works is hindi sila yung may prior knowledge or may personal knowledge kung anong nangyari during tendering and bidding works. So palagi kong sinasabi yan na dapat mayroong tender report kasi later on, yun lang yung magsasabi na hindi during bidding, ito yung napag-usapan yan. Then the issues will be resolved as early as the time na nag-raise ng questions either the contractor or the owner's representative. Then the contract to be considered in context and as a whole background of the transaction. Ito na yung kanina. Clauses will be interpreted against the party who drafted the document. So kung sino nag-draft ng document, dapat ang interpretation is not favorable sa kanya. No, yung tinatawag namin na contra proferentem rule. Kasi it's unfair naman, ikaw na nag-draft, tapos yung interpretation is favorable pa sa nag-draft ng kontrata. So kawawa palagi, walang magawa. Yung nagki-query, no, walang magawa yung contractor dahil sasabihin niya, hindi, ako nag-draft niyan, ito ang sinasabi niyan. So hindi. Okay? So that clause shall be interpreted against the party who drafted the documents. Okay? So kaya tinawag na contra preferentem rule dahil kontra sa kanya dapat ang magiging interpretation ng clause na yon. Okay? And then a more reasonable interpretation will be preferred in case of ambiguity. So kung ano yung reasonable diyan, yun dapat ang gagamitin because that portion na magkakaroon man ng ambiguities later on, it should be favorable palagi sa project, not for the interest of both parties, but for the interest dapat ng project, what is reasonable to the project. Okay? Then literal meaning will not be applied if this leads to an absurd result. Okay? And then the express mention of one thing will be read as meaning the exclusion of another thing. And the handwritten or especially added clauses will take precedence over the standard form. So kung mayroong binura dyan and pinalitan ng sulat kamay ay mag-prevail. Okay? Cross-out words may be considered as long that it is sa atin is usually mayroong initial, no? That crossing out of the words was agreed by the parties. And where there is a list followed by general words, then the general words will be restricted by reference to the same class of things previously mentioned. On CF 102, mayroon tayong interpretation of contract din na provisions, no? And this CF 102 is the one being used also by the Supreme Court in interpreting technicalities with regards to construction contracts. Ang equivalent nitong CF 102 sa atin is yung UAP document 301. But I don't know if the UAP document na-update, no? Parang hindi yata na-update. But SIAC, no, the arbitrators and the courts use CF 102 as the industry practice in the Philippines. So if there is an ambiguities later on, pag nagkaroon ng arbitration, i-resolve ng SIAC yan. Pagka mayroong clause, pero hindi malinaw yung clause, i-resolve ng SIAC arbitrators yan with the use of this SIAC 102 conditions of contract. Okay? So interpretation in case of conflict between the provisions of the agreement or of any contract documents, or between the provisions of one of the contract documents and the provisions of another contract documents, or in case of discrepancy, defective description, error, or omission in the contract, the following rules shall be followed. Rule number 1, the agreement and the contract documents shall be taken as mutually explanatory of one another. The various provisions of the contract shall interpret together, attributing to the doubtful ones that sense, which may result from all of them taken jointly. Rule number 2, the provisions of the Civil Code of the Philippines on the interpretation of contracts and of the rules of court on the interpretation of documents shall apply. Kaya dapat meron din kayong civil code, no? Nagbabasa rin kayo palagi ng civil code kasi malaking bagay sa atin yung civil code dahil doon palagi bumabalik yon sa provisions ng civil code pagka mayroong ambiguities to interpret, no, sa rules on obligations and contracts. And rule number 2, rule number 3, the conflict between or among the provisions of the agreement and or the contract documents cannot be resolved by rules 1 and 2. It shall be understood that the detailed drawing shall prevail over the general drawings. Kaya napaka-importante yung mga specific details. Kasi pagka merong specific details, compared doon sa general drawings, specific details shall prevail. Words and figures shall prevail over the drawing. So kahit may graphical presentation ka, ang words ang mag-prevail. Kaya nga sinasabi natin, di ba? Specifications prevail over drawings. Okay? Words shall prevail over figures in contract documents. Okay? Kung meron kang amount, yung amount mo is naka-numbers. Pag may words, words shall prevail. And then written dimensions shall prevail over measured dimensions. Okay? And then where the conflict cannot be resolved by applying Rule 3, or where Rule 3 does not apply, the conflict shall be resolved by giving precedence to the agreement or to the provisions of the contract document higher in order of priority among the various documents which comprise the contract. The order of priority among these documents shall be as follows. Agreement as modified by the notice of award or the notice to proceed, instruction to bidders, addendum to bid document, specifications, drawings, special conditions of contract, other documents. Okay? Ang kadalasan na ginagawa ng mga consultant natin is that they resort automatic to this hierarchy of documents. No? So pagka there is a discrepancy between the provisions of the contract, usually dito sila sa rule number 4 tumatakbo. No? Hindi mo na nila tinitingnan yung rule number 1, number 2, and number 3. But in CIAP 102, sinasabi doon as industry practice, dapat titingnan mo muna under rule 1, 2, and 3. Pagka hindi ma-resolve ng tatlo, doon ka palang dapat tatakbo sa rule number 4 to check the hierarchy of the documents kung saan ang mag-prevail. But before you can go to rule number 4, you have to apply first rule number 1, rule number 2, and rule number 3 of CIAP or CIAP 102. Okay? So, napaka-importanting bagay ang interpretation ng contract dahil palaging may mga ambiguities yan, no? Na hindi na re-resolve kaagad kaya nag-trigger ng arbitration. Okay? And rule number 5, where there is a discrepancy, defective description, error, or omission in any contract document, the contract documents shall be interpreted as being complementary to each other. Thus, what is called for in the contract documents, although not mentioned in another document where it should have been mentioned, shall be deemed to be called for by the contract. Kaya maghahanap ka palagi ng mga dokumento na may nababanggit pa doon sa kabila. Kasi kung nababanggit doon sa kabila, kahit hindi nababanggit dito, nababanggit siya dahil nandun siya sa kabila. Complementary sila. Okay? The apparent silence of the drawings, specifications, or any other contract documents as to any detail, or the lack of detailed description concerning any part of the work shall be understood to mean that good and accepted construction practice in accordance with the usage or customs of the place shall be followed. Ito yung mahirap dito. No? Pag sinasabi natin na, edi kailangan gawin mo sa in accordance with the industry practice and standards. Ang tanong is, what standard are we referring to? No? Nasaan ba yung Philippine standard with regards to private construction contracts? Nasaan yung standard with regards to international construction contracts? Okay? So may mga problema pa rin kahit may rules. Okay? And then sa Rule 7, Rules 1 to 6 shall yield to specific rules of interpretation in this document or in the contract. Okay? So the owner shall resolve the conflict or interpret or explain such discrepancy, defective description, error, or omission with due regards to Article 2.04. The interpretation of or explanation of the owner shall be issued in the form of instructions to the contractor. Where the owner fails to issue the instruction in writing, the execution of that part of the work affected by the interpretation or explanation without a timely objection or protest of the owner shall be deemed to have been executed in accordance with the owner's explanation or interpretation. So lahat ng mga sagot dapat ni owner nakaput in writing, and the contractor should answer. Kung mayroong sa tingin ng contractor, for example, hindi tama sa interpretation, dapat the contractor should respond to the owner. Otherwise, pagka hindi nag-respond si contractor, no, in a reasonable length of time, ibig sabihin, he accept the interpretation of the owner. In all cases where a device, item, or part of equipment is referred to in the singular number, it is intended that such reference shall apply to as many such devices, items, or parts as are required to complete the work. So kung meron mo na-describe na isa lang, it relates to all others item na kapareho ang kanilang description. Okay? So conformity to the contract, the work shall be executed in accordance with the contract. Kasi ang binding between the contractor, the owner, and the owner's representative are those what is stated in the contract documents, those what is stated in the agreement between the contractor and the owner, and what is described in the drawings and specifications. So all conformities shall be referred to in the issued contract documents by the owner to the contractor. The owner shall be responsible for adequacy of the design and for sufficiency of the drawings and specifications. The complete requirements of the work shall be set forth in drawings and specifications to be supplied by the owner. Dito critical ang role ng isang architect. Kasi sinasabi ng conditions of contract ng SIAP na ang adequacy of design to be provided by the owner shall be with sufficiency of drawings and specifications. So pagka nag-provide ka lang, for example, ng for building permit purposes, and whatever cost attributable to the owner later on dahil hindi na isama ng contractor, then babalik yan sa kay architect. No? Kasi malinaw naman sa conditions na dapat sufficient ang drawings, no, to complete the project, not only to complete the project, but to give the contractor, the bidder, the exact amount of the project to be bid. No? Kasi pagkakulang, siyempre kulang din yung bid ng contractor who will shoulder now the cost pagdating sa part ng owner pagka hindi nagkaroon ng allocation of budget. Okay? In the event that any part of the whole of the works when agreed upon are designed by the contractor, then all responsibilities assigned to the owner for the design shall automatically be assigned to the contractor as his responsibility. So, si contractor has the responsibility to provide details subject for the consultant's approval and acceptance on the details of the work. Okay, now, bills of quantities. May pinoprovide na bills of quantities from the owner's representative, like architects, or sometimes the owner hires the services of a quantity surveyor. And what is the role of the quantity surveyor? No? It quantifies the works, it quantifies the scope of works, and provide it to the consultant. But, in the bills of quantities, palaging nasa safe side ang consultant ng owner. No? Ang sinasabi nila palagi, what I mentioned as early as we started this discussion, sinasabi palagi ng representative ng owner, no, especially yung mga quantity surveyors, na nagbibigay kami ng bills of quantities. We list down scope of works, but you have the duty, you have the responsibility to scrutinize everything. And what is not included in that bills of quantities, you have to provide. Okay? Wala kaming kinalaman dyan pag nagkulang ka. No? Dahil ikaw dapat ang kukumpleto ng bills of quantities. Kung nakikita mo na ito yung sinasabi ng drawings, ito yung sinasabi ng specifications. Okay? Kasi may mga conflicting, no? Nagko-conflict ang ating bills of quantities with regards to the scope of works, no, na dinidescribe ng drawings. And that bills of quantities, if it is incomplete or inaccurate, no, then that will trigger later on for an additional cost to the owner. Ang tanong doon, nakalagay ba sa kontrata? Nakalagay ba sa instruction to bidders that the contractor has really the full responsibility for that completeness of the scope of works in the bills of quantities? Ano ba ang sinasabi ng kontrata with regards sa bills of quantities? Kasi mayroong mga kontrata na ang description sa bills of quantities is only a reference for measuring progress accomplishment and nothing more. Although meron nakalagay ng mga scope of works. So kung yan ang nakalagay, that will only be the purpose of the bills of quantities and not to be used as the completeness of the scope of works of the contractor. Pero pag walang nakalagay dyan, of course, may liability si architect. May liability ang consultant ni owner kung hindi naman malinaw na the contractor has the responsibility to complete the scope of works in the bills of quantities, lalo na in-issue yung bills of quantities na nandun na ang scope of works, no, na ginawa na ng consultant ng owner. So, you have to check, you have to verify, you have to make a clause kung saan protected ang owner, no? Or of course, si contractor dapat protected din si contractor. Well, later on, it boils down with the negotiation, no? Kung sandali unfair sa amin, no? Fair sa iyo palagi. No? So, baka magbago rin yung clause. But at least it has been observed, it has been negotiated at the early stage of the negotiation, no? And then later on, during the implementation of the work, walang problemang lalabas regarding dyan sa listing of scope of works. Otherwise, it will trigger as a variation. Okay. Variation powers. Napaka-importante ng variation powers. Okay? So, ang sinasabi ko kanina is that pagka walang variation powers, walang authority ang owner's representative or the project manager of the owner, walang authority to issue a variation. Okay? Kaya nga dapat mayroong variation clause. Pag walang variation clause ang kontrata, ibig sabihin, there is no authority to vary the works. So ano sinasabi ng variation powers? Is there really a need for a variation clause? Okay, so rare sa isang construction contract na mag-perform without some variation to the original scope of works, no? Kahit saan construction ka pumunta, napaka-imposible na walang changes, napaka-imposible na walang nakalimutan, and that is considered as variations, no? Either will it be a deductive variation, will it be an additive variations, okay? So ang variation power napaka-importante, no? Kasi pagka walang variation power, walang authority ang consultant ng owner to perform variation, okay? Sinasabi nga dito, any insistence with the principal to vary the works to be performed absent or outside a variation clause may provide a basis for the contractor to claim that the principal repudiated the contract. So pag walang variation clause, tapos mag-vary ng owner, nag-breach of contract si owner. Dahil sinasabi ni owner, sandali, gusto kong baguhin yung ganito. No? But si contractor said, sandali, wala tayong variation clause. Ibig sabihin, naka-fix na tayo sa ganito. Wala ka nang dagdag pa. No? Pagka yan ay hindi granant ni contractor, ni owner for example, no? Merong claim si contractor, ibig sabihin, si owner magre-repudiate ng kontrata and mag-trigger kay contractor to claim for the breach of contract, no, sa part ng owner dahil hindi niya papayagan, for example, yung claim ni contractor, no. So yung mga dagdag pagka walang variation clause, ibig sabihin walang power, walang authority to vary the works. Pero it's unfair for the side of the contractor na walang variation clause. On the part of the contractor, dapat si contractor is nagre-review talaga and see to it na na-consider itong variation clause. Okay? So contract provisions usually define variation widely to give the project manager or the architect flexibility as to what the contractor may be directed to perform. And well, hindi unlimited dapat ang variation power ng architect or project manager, although we are given the flexibility, no, to give contractor a direction to perform a variation. So the project manager or an architect may vary the work under the contract by one or more of the following: increase, decrease, or omit any part of the work, change the character or quality, change the levels, lines, positions, or dimensions, carry out additional work, or demolish or remove material or work no longer required by the principal. Di ba usually common sa industry practice na naisipan ng owner, hindi na natin gagawin yan. No, tanggalin na lang natin to. So that is an omission of works. But some contractors said that, sandali, lump sum contract ang aming sinara dito. No, dapat walang mababawa sa amin. Otherwise, magsasuffer kami ng aming overhead dahil ang overhead and yung mga equipments was program based on that lump sum contract dahil ito yung scope of works na nakapaloob. So kung tatanggalin nyo yan, magsasuffer ang aming overhead, no, and the manpower required na nakaalat na kami. So nagiging trigger for variation. But the project manager or an architect can increase, decrease, omit any works as per CIAP 102 documents. But of course, if the contract of the contractor and the owner na-execute is not relying with the CIAP 102, kung ano yung nakalagay doon sa clause ng kontrata nila, that will prevail because that is the law between the parties. Okay? Pag wala lang provision sa kontrata, then that's the time that you will resort to CIAP 102 as the reference for industry practice. Okay? So express power of the project manager or the architect. Under construction contracts, it is usual that the project manager or the architect would not generally have an implied authority to vary the relevant construction contract. It would be necessary to show that any directions given by the project manager or the architect to the contractor to perform a variation were within their express authority. However, as it is the principal which requires the variation, the project manager or the architect must act as the principal's agent in carrying out that power. If we're going to go back later, recently, doon sa diniscuss kong Article 1724 ng Civil Code, di ba? Malinaw na nakalagay doon that the power to instruct changes in the work is to the proprietor. And the proprietor referred here is the principal or the owner. So, ang owner lang ang pwede mag-instruct ng variation. Walang power and authority sa architect and project manager unless there is an express authority from the owner. Kaya palagi namin inahanap yan, no, sa mga bidding or sa mga during construction work, pagka mayroong owner's representative or meron silang project management, hinihingi namin yung scope of works ng kanilang representative. Kasi mayroong instances na yung kanilang representative nag-encroach sa power ng owner. And then later on, pagka may problema and mag-claim na si contractor, sasabihin ng project management firm na sandali, CM kami rito, construction manager kami rito, hindi kami project manager. No? Pero, the time na nagpe-perform sila, they're encroaching the power of the project manager or the owner. So usually hinahanap namin, ano ba talaga yung scope of works nyo or ano talaga yung kontrata na pinirmahan nyo sa owner para alam namin kung paano rin kami makikipag-usap sa inyo. No? Kasi merong mga construction management na CM ang role nila kay owner, pero PM sila pagdating sa site or PMCM pagdating sa site. Take note, there is a difference between the role of a construction manager and the project manager. No? The construction manager, of course, project execution, while the project manager is they are more on time, no, more on cost, no, and of course supervising the whole organization. So minsan PMCM na ang nagiging performance ng ibang firm, and later on nagkakaproblema, no, kasi pagka may claim si contractor, sandali, si owner yan, bahala, wala kami diyan, CM lang kami. No, but sila yung nag-issue ng mga instructions. Okay? So, yan. Variation limit sa CIAP 102, meron na nakalagay na variation power and yung variation limit. So, there is a changes order by the owner na provision sa CIAP 102 under clause 20.07 that says the owner may at any time, di ba? Yung sinasabi palagi dyan is the owner may at any time, not the owner's representative. No? Kasi ang owner lang ang may power to instruct a variation. So, sinasabi ng ating CIAP 102, clause 20.07, the owner may at any time order extra work or make changes by altering, adding to, or deducting from his scope of work and within the general scope thereof, provided, however, that the resulting overruns or underruns from the quantities or cost in the bid do not exceed 25%, does not exceed 25%. Such changes shall be ordered by the owner in writing. So may limit, no? May limit yung pag-issue ng change order, may limit yung pag-umit, no, as deductive change order. Hanggang 25% lang. Pagka naglagpas ng 25%, the contractor can request for the termination of the contract dahil kakainin na ang kanyang profit margin. No, kasi sa overhead mo kung 15%, profit margin mo is 15%, you have a total of 30%, no, between overhead and your profit. Eh kung 25% na yung inumit sa'yo, ang 15% at 15% yan, 30% yan yung profit mo. Malaki yung mababawas sa isang contractor. And the variation power, ang second paragraph ng 20.07 is the variation power. Okay? Sinasabi diyan, the issuance by the owner of the revised drawings or supplemental specifications changing the nature or work to be performed or of the materials, equipment, appliances, or fixtures to be provided shall be treated as sufficient written instruction of the owner to the contractor to execute the change. So under CIAP 102, pag nag-issue ng drawings, may perma yung owner sa drawings, okay, coming from the architect, considered na siya, no, as sufficient instruction from the owner. Yan ay kung gagamitin mo ang conditions of contract na CIAP 102. Pero pag hindi, usually walang clause na ganito, no, and you rely with some other documents na kailangan may perma si owner, instructing the owner's representative, instructing the owner's architect, instructing the owner's project manager na magkakaroon ng changes of the work. So kung CIAP 102, wala tayong problema dahil merong express variation power, no? Express variation limit. Pagka wala, so you have to check, no? You have to review with the conditions of contract and mag-recommend ka ng changes in the clause that would also, if not favor the contractor, then make it neutral between the contractor and the owner. No? Being an architect sa side ng owner, dapat hindi rin tayo pro-owner. No? Kasi karamihan, di ba, nagiging pro-owner tayo. No? If we are an architect as a designer, iba yung role natin. If we are an architect as a project manager or owner's representative, iba rin yung role natin. So we have to be balanced between the owner and the contractor. No? Dapat na-explain natin sa owner na maigi na ito yung role natin. Kasi ang ating interest dyan is for the good, no, and for the expeditious completion of the project based on contract, no. Hindi yung si contractors gaganin natin, no, kailangan sa owner tayo, no? So yung role natin is to balance between the contract of the contractor and between the owner. Okay, timing, no? Based in the common law, in the absence of any express terms covering the period within which the superintendent or the project manager is entitled to direct the contractor to perform a variation, variations may not be directed after the works have achieved practical completion. In the case of J.W. Jamison Construction Limited versus Christchurch City, the court confirmed that the entitlement in the general conditions of contract for the architect to direct the contractor to perform a variation did not remain in force after the certificate of practical completion has been issued. Ang pinakamalinaw dito is that hindi na dapat tayo pwedeng mag-issue ng variation orders pag nakapag-achieve na ng completion date si contractor. Bawal dapat. No? Although, yung iba, nasa 95% na si contractor, nag-i-issue pa ng mga additional works. No? So, dapat bawal na, no? Yung pag-issue ng mga variations orders pagdating ng completion or nakapag-achieve na ng practical completion si contractor. It's unfair for the contractor na outside na ng kanyang contract, nag-i-issue ka pa ng mga additional works na hindi naman kasama doon sa kanyang original scope of work. So variation orders shall be treated only from the time of the commencement of the work up to the time that the contractor completed the work or substantially completed the work. So 95% yan under CIAP 102. Outside of that, hindi na dapat tayo pwedeng mag-issue ng variation orders. So the date for submission by the contractor of his final account, an account to cover the whole of the works with variations. Kasi ang point natin doon, dapat nung na-achieve na ni contractor ang kanyang substantial completion, dapat nagsisimulan na rin ang determination natin ng final account ng contractor. Para pagdating ng 100%, mag-i-issue ka na lang ng certificate of acceptance, and that's the time na tatakbo na ngayon ang running of defects liability period, okay, which is equivalent to 1 year. Okay, so yan. And then contractual and other limits on what constitute a variation in the Canadian state, no? Meron silang guidelines din, no, that considers whether an item of work or work is a variation or an extra work to the contractor. Number one, an item specifically provided in the contract was not an extra. So whatever listed in the contract, kung ano man ang incidental to that scope of works na nasa contract, that is not considered as an extra, but can be treated as a change order but not as an additional order. If the contractor supplied material of a better quality than the minimum quality necessary to the fulfillment of the contract without any instructions, shoulder the contractor. Okay? So kung ikaw naman ay architect, design and build ka, may naisip kang magandang quality ng materials, without approval of the owner at in-execute mo yan, hindi mo pwedeng isingil kay owner. No? So dapat may approval ng owner pagka binago mo ang materials na gagamitin doon sa naisip mong paglagyan. Okay? If the contractor did work or supplied materials not called for by the contract, hindi naman sinasabi ng kontrata na itong material, pero karoon ka ng initiative para gamitin, sasabihin mo, for the benefit of the owner naman, kasi maganda to, magugustuhan ng owner, that will not be treated as a variation. Okay? So hindi ka babayaran ng owner without such instruction, no, na magbigay ka ng additional materials, no, na mas maganda yung quality or additional works na magiging extra. And then if the contractor did work or supplied materials not called for by the contract but on instructions expressed or implied of the principal, he was entitled to charge for such additional work or materials as extra. So, wala sa plano, no, nag-supply ka ng material, wala sa kontrata, pero may instruction, so pwede kang sumingil because that was covered by project manager's instructions as approved by the owner. Okay? So, yan. Cumulative effect of multiple variation. Ang cumulative effect sa multiple variation is that later on, pagka ikaw ay nag-execute ng works and magkakaroon na ng disruptions of works with other allied professionals also, that will trigger as losses on the part of the contractor pagka hindi ka rin nabigyan ng iyong time element, no? Kasi cumulative effect of multiple variations will trigger for lengthening, no? Additional time element for the contractor. Dahil ang iyong contract sa owner, like for example, meron kang number of calendar days. That calendar days was computed only based on the scope of works laid down during the tendering works. So if there is a lot of variation, cumulative variations during the construction period, that will add up to your time element that later on the contractor will suffer if the owner will not also grant an element of an extensions of time. So if there is a cumulative variation, the effect of that is the contractor will suffer, no, of that time element incurred if the owner will not grant the contractor an additional time to make that contract extended, no, extended from the original timeline agreed. Okay? So omission of the works, well, malinaw naman kanina that the power of variation is whether you have to delete portion of the works, omitting the works of the contractor, not really not to be done anymore, no, under the contract, kaya tatanggalin na ng owner. But the critical issue here is that yung omitting the work dito sa portion ng conditions of contract is that sa omission of the works, if it is to be omitted by the owner, no, and hindi na talaga gagawin, the contractor cannot claim for a variation orders or cannot claim for a deductive variations and claim for loss of profit or loss of opportunity kung hindi na talaga kailangan ng project. But if the portion of the work is omitted to the contractor and that omission of work was given to the other contractor, then that's the time that the contractor can claim for the loss of profit. Ang critical lang is that dapat pag inumit sa iyo yung work, it is not yet within the timeline that you are going to do the work. Kasi kung yan ay inumit sa iyo dahil hindi mo ginawa na nasa time frame mo na dapat na gagawin yung trabaho, then the owner has the right to omit the works to the contract of the contractor dahil hindi mo na perform ang iyong contractual obligation. But if it is not yet the timeline for you to do the works and inumit ng owner, binigay sa other contractor, then that's the time that the contractor can claim to the owner a loss of profit and the loss of opportunity involved in the contract. Okay? So, claim for extra cost to the owner, mayroon tayong timeline of 15 days. Okay? So, dapat nakapag-claim ka na kay owner ng within 15 days. Otherwise, pagka hindi ka nakapag-claim within 15 days, hindi ka nakapag-notify within 15 days, pwede kang mabarred, no? Magkakaroon ng time bar and hindi ka na makakapag-claim ng extra cost sa kaya owner. So critical yung mga timelines, no? Dahil technicalities, pagka ito ay hindi mo nasunod, no? Pwedeng magkakaroon ka ng losses sa iyong project. Okay? So now let's go with the effect of COVID-19 pandemic in construction contract. So nowadays, alam naman natin yung nagiging problema natin with this pandemic. All construction works were stopped, no? And until now, hindi pa nakabalik ang karamihan. And mostly ng mga construction firms even retrench their employees, no, because of the effect of this pandemic. So, what are the challenges now and protection of the contractor on this COVID-19 pandemic, no? Usually in a construction contract, mayroon tayong tinatawag na delay clause, no? Kasi ang problema ngayon ng mga contractors that they are now delaying, no, with the completion of the works because of this COVID-19. So ano dapat ang protection ng contractor, no? One way is that there should be a delay clause, no, also known as force majeure clause, no. Well, majority ng kontrata merong force majeure clause. Paano pag wala? So pag walang force majeure clause, minsan mahirap, no, dahil wala kang protection. And majority ng mga force majeure clause, it does not mention their pandemic. What you can read sometimes is that epidemic. Diba? So pagka-epidemic, it's only a small community affected, no? While pandemic is affected worldwide, no? So how the court later on appreciate, no, pagka halimbawa yung nakalagay diyan is only epidemic and not pandemic. But I presume that the court would really allow such a claim for an extension of time, but you cannot claim for a cost. Okay? So, force majeure or delay provisions or provisions for an act of God, although hindi na natin ginagamit ngayon yung word na act of God, but we usually use act of nature, no? Kasi sinasabi natin, pagka act of God yan, hindi naman natin masusu in court itong mga obispo, yung mga pastors as representative of God here on earth, no? Alangan naman kakasuhan natin yung mga pastor sa obispo, di ba? O, ito nangyari ngayon dahil ginawa ng Diyos. So, we change it now into the acts of nature and not the acts of God. So, a force majeure clause is a type of contractual provisions that relieves a party's obligations under the contract which when circumstances beyond the party's control arise. Force majeure is a French word, superior force. As such, these provisions are meant to cover events traditionally deemed as acts of God or acts of nature. So, pagka nagkaroon ng force majeure, we are relieved by our liability to the owner. Na kahit hindi natin matapos yung project on time, hindi natin magawa ang kailangan tapusin, medyo safe tayo doon dahil nandun tayo sa clause ng force majeure. Pero ang tanong doon is, how can be compensated later on? Diba? Kasi ito ay hindi naman kasalanan ng both parties. So majority, ang pwede lang i-claim ni contractor sa owner is only a claim for an extension of time and not for the claim cost element. Okay? Anyway, malapit na tayo matapos. Okay, so under CF 102, an act of God or a force majeure is a grounds for claim for an extension of time, but not a grounds to claim for additional cost in the contract. Okay, so time element lang ang pwede natin i-claim sa extensions of time, sa contract. Okay. Under Article 1174, pag walang force majeure clause ang kontrata, pwedeng gamitin ang Article 1174 ng Civil Code. No, ito yung sinasabing fortuitous event, no, because sa fortuitous event and force majeure usually use interchangeably, no. So kung walang force majeure clause, we can use as grounds for the entitlement to claim for an extension of time itong Article 1174, which says that except in cases expressly specified by law or when otherwise declared by stipulation or when the nature of the obligation requires the assumption of risk, no person shall be responsible for those events which could not be foreseen or which, though foreseen, were inevitable. So ito yung safe side pagka walang force majeure, so hindi problema sa kontrata. But the question is how the courts treat force majeure. No, kasi in one case, sa case ni Ace Agro Development Corporation, no, force majeure din ang issue. Pero anong sinabi ng korte? It was held that the period during which work is suspended due to force majeure does not justify an extension of the term of the contract. So depende rin, no, sa pag appreciate ng court kung pwede kang i-grant ng extensions of time or hindi. Okay? So, yon, nowadays, construction companies lay off more or less 300 indirect support employees. Some projects were stopped because of this pandemic. Okay? So, thank you and have a good day to all.
Ayan. Thank you, Sir Alfred. Thank you, Maestro. Ayan, ako. Kinakabahan kasi ako kasi mag-off time limit na baka mawala tayo. Tsaka narinig ko po, kumikidlat na dyan sa background niyo, sir.
Yes. So, actually, umuulan ngayon sa area ng
Yun nga, sir, natapat po ako, mami, mawalan po tayo ng connection. So, thank you, sir, sa sobrang magandang presentation nyo at sobrang dami namin natutunan about change order, variation order, additionals. Ayan po, parang kailangan pa ata ng mas maraming time or parang a workshop for this kasi nga sobrang dami pa po dapat na matutunan at sobrang
area.
yes, po, part pa lang po siya ng kontrata, hindi po siya yung buong kontrata, so what more pa kaya yung buo. Ayan, so after that, sir, pipresent ko muna sa inyo, sir, ang inyong certification before tayo, kung may time pa, mag-question and answer. So, babasahin ko po. United Architects of the Philippines. Ay, nakikita po ba?
Yes.
Okay. So, Quezon City Capital Chapter hereby present the Certificate of Appreciation to Arbitrator Architect Alfredo A. Fernandez, in grateful recognition for imparting his valuable insights and inspirational thoughts as speaker. This certificate is in gratitude of meeting us in this online setup for UAP QC Capital Webinar Series 4, entitled Variations and Change Orders as the Effect of COVID-19, How It Affects Construction Contracts. Given this 25th day of July 2020 via Zoom, signed yours truly, Architect Ray Andre Ilustre and Architect Rogie Jude Ramos, Vice President for Operations. So, ayan, thank you, sir.
Thank you.
Sabi nga po, kulang po yung oras, sana may part 2 pa daw, sir. So, habang hindi pa tayo nawawala, no, pwede kayong mag-type in ng questions nyo at baka pwedeng makasagot pa si Sir Maestro. Ayan. Pero habang wala, sir, di ba? Parang binanggit niya, sir, ayun, ito yung question pala, last copy talk 1. Paano po yung change sa site? So, sino pong mag-shoulder nung mga changes dahil sa COVID? For example, yung PPEs, ayan po. Kasi sobrang mahal po yan eh. Ngayon, as of now. Tapos, for example po, kailangan din po magpa-test ng mga workers natin sa site. So, paano yun, sir?
Well, the DOLE, no, naglabas ng kanilang memorandum, no, ang sinasabi nila that the owner should shoulder the cost of this testings, no, and other PPEs. But of course, kaya hindi nagre-resume yung mga construction din ngayon dahil it needs to renegotiate with the owner dahil ang owner umaangal din sa cost. So dahil talagang malaki, and this testing is not only once gagawin dahil di ba? Pauuwiin mo ang iyong mga empleyado ngayon, papabalikin mo sila sa susunod na araw, naghihalo na naman sila doon sa kanilang pamilya. Mayroon na namang presumption na baka nagkaroon ng COVID, no, sa isang empleyado. In fact, it will also cost a lot for the loss of time, no, dahil araw-araw pipila sila, mag-temperature check ka, no? And napakahirap, 'di ba, sa construction na magkaroon pa ng social distancing pag nagtatrabaho, no? But yun nga, umaangal din yung mga owner dahil malaking cost din ang claim ng contractor. And because of this 30% lang na required na magtrabaho ngayon sa construction, mas hahaba ang iyong time element ngayon, dapat magkakaroon ka ng extended time element, and may kaakibat dapat na additional overhead cost, no, dahil yung rental mo na equipments, no, and other thing.
Ayan. So, thank you, sir. So, siguro, pag may mga ganyang additional cost, sabi nyo kasi kanina, di ba, na kailangan mag-request sila or si architect yung magre-request sa owner for this.
Well,
Ayan.
ganito, ang nagiging problema natin dyan minsan is that majority of the contractors did not or do not review the clause of their contractors' all risk insurance, no? And of course, pagka kumuha ka ng carry sa isang insurance company, pagka hindi mo yan ni-review at hindi mo sinabi sa kanila na ito dapat ang i-insured, ang gagawin sa iyo ng isang insurance company, bibigyan kanila ng sarili nilang template, and kabaliktaran yan minsan, no? What is potential risk is exclusion, and what is lesser yung risk, yun yung inclusion sa carry. So hindi yan bibigyan ng pansin na ma-review yung provisions ng carry, na dapat yung halimbawa pag may pandemic na ganito, dapat inclusion sa carry para later on pwedeng i-claim sa carry ang ganitong pangyayari. So ngayon kasi yung itong force majeure na mga ganito sa carry, standard nila yan that it is an exclusion to the insurance to be paid. So wala kang makukuha doon, no? Kaya sinasabi ko dapat nire-review rin dapat ang carry, and see to it na lahat ng mga potential risk na pwedeng mangyari sa construction works, dapat yun ang nakalagay doon as inclusion sa coverage and not to be part of the exclusion. Kaya di ba, tuwan-tuwa yung mga insurance pag kumuha ka ng carry kasi madalang lang yung nangyayari sa site dahil yung mga minimal risk, yun yung nakalagay doon sa inclusion. Yung mga potential risk talagang hindi nakalagay doon as inclusion. So kawawa yung contractor.
So dapat pala, sir, included na pala siya sa insurance before pa. Pero paano yan, sir? Siyempre natin na-expect na merong COVID o mangyayaring pandemic. Paano ngayon yung mga claims ng mga existing na ng mga projects or mga contracts?
Well, sa ngayon, wala talaga, no, maliban sa time element, dahil pagka ganyan time element lang talaga. Kaya sabi ko nga, it's parang mahabang renegotiation between contractor and the owner, no? Kaya nga pag tinignan niyo, there were a lot of contractors na almost 30% ng project nila is talagang terminated, no? Dahil hindi talaga papayag din yung owner that all costs shall be shouldered by the owner.
So, ganun pala talaga, sir, no? So, ang hirap talaga. So, kailangan may renegotiation. So, dapat, yes, ang dami nga, sir, na nag-stop yung work as of now. Dahil nga, wala ng budget.
Yes, agree. And hindi na nila masustain din yung pasahod mo, di ba?
Yes, sir. Nga po eh.
No, yung ating mga nasa head office natin na overhead ng site yan. No, kung hindi nakakapag-function yung project sa site, what will be the salaries that you will be paid to those working in the head office? No, kasi ang pinapasahod sa mga yan, kinukuha yan doon portion sa binibill ng mga project sites natin. So kung hindi gumagalaw ang project sites mo, saan kakakuha ng pasahod ng mga nasa head office natin, yung mga accounting natin, di ba? So yun.
Oo nga, sir. Yes, sir. Tsaka yung mga na-stranded ng mga construction workers sa site, di ba, sir? So, usually, ano pa yung nagpapakain eh? Sino pa nagpapakain, sir? Si owner o si contractor?
Well, merong owner kasi na hindi, no? Katulad nung dating malapit sa akin dito, yung nag-post dati sa TV na wala na silang bigas, no? Tumulong tayo kahit papaano doon, nagdala ako ng mga bigas. And nalaman ko that they are subcontractors only of the main contractor. No? At biruin mo, hindi sila binigyan ng pansin ng kanilang contractor. So nakakaawa yung mga taong yun. Diba? So which is dapat, responsibility rin dapat ng mga main contractor na tulungan din. But of course, hindi natin masisisi kasi itong nangyari na pandemic na to is hindi talaga included sa kanilang cost allowances. Diba? So kayang talagang hindi nila kaya siguro masustain yung cost din dahil sa kanila palang empleyado is baka kulang na rin yung kanilang resources.
Ayan, thank you, sir. So may question pala dito, sir. So last question na po ito. Sabi niya, from Architect Dexter Mojica, Maestro, paano kung may binago sa approved design ng architect, PM or contractor, sa tingin nila na magiging maganda at mas mahal ang magagastos at hindi na need magkaroon ng variation order, VO, pero nang makita, ano ba to? Nang makita ng owner ay hindi niya nagustuhan at pinabalik ulit sa original design. Sino ang magbabayad ng gastos para ibalik sa original design?
Well, if it is approved by the owner at pinabalik ni owner later on, gastos ni owner. Okay? Pero pagka halimbawa is walang approval ng owner, no? And yung nagpa-implement lang is the representative of the owner. So, gaya nga na sinabi mo kanina, walang express authority ang representative ng owner to instruct the contractor to do any changes without express authority from the owner. Dapat may express authority from the owner palagi. Otherwise, the owner will not pay you. Will not pay you anything.
Yes. Sabi nga, sir, dapat nasa writing yan, sir. Eh. So, dapat nakalagay talaga siya or merong approval ni owner para ma-claim mo, di ba, sir? Yes. So, sabi nga ni sino ba ito? Hindi ko makita yung full name. From Manila Centrum, speaking of force majeure, the scenario happens to be semi-halted since hindi totally natigil ang trabaho pero bumagal yung progress dahil half of the workforce na nagsiuwian, di nakabalik because of ECQ. The question is, hindi ginagrant ng PM na i-extend yung work schedule na pinopose ng contractor because may nagtatrabaho daw sa site. O nga sir, paano daw to sir?
Okay. Kaya nga, ang aming advice dyan sa mga nagko-consult din sa akin, no, being the owner and the contractor, my advice dyan is that don't let them work ng lesser yung productivity, no, kasi although generally that is covered by force majeure, pero nagpatrabaho ka, you will assume the risk, no? And that is considered dapat na loss of productivity. Pwede kang mag-claim ng loss of productivity pagka may instruction from the owner. Ngayon, pag walang instruction from the owner, ikaw lang nagpatrabaho, ang sinasabi mo, hindi magtrabaho tayo kahit kakaunti lang tayo. And walang proper instruction, you will suffer for that loss of productivity. Pero pagka yung owner, for example, na nag-instruct na, sige, yung natira mong tao dyan, pagtrabahoin mo lang kahit kakaunti sila, then you can claim to the owner for that cost of your loss of productivity dahil may present instruction. So what our advice there is that wag magpatrabaho ng kakaunti lang yung tao pag walang instruction, otherwise you will suffer.
Ayan. So agree kay Sir Maestro, no. So I think hindi na tayo makakasip ng mga questions. So kung may questions pa kayo, i-PM nyo lang si Maestro. Ayan, kumikidlat na. Or, di ba Sir Maestro, meron kayong YouTube channel. Parang nakita ko yung may YouTube channel kayo. Pwede nyo sir i-promote para pwede kayong manood din doon. Ay, mukhang nawala. Hello, Maestro. Naku, mukhang nawala ng kanyang internet. Wala na ba? O nag-lag lang? Ayan, so check nyo na lang, i-add nyo na lang si Maestro. So ang Facebook name niya is Maestro Alfredo Fear Non-Dis. Ayan, so kung i-add nyo siya, pwede kayong mag-question sa kanya or i-follow nyo siya sa kanyang YouTube channel. Nasa Facebook niya rin. And then meron din siyang book, which is in-announce ko kanina. Ayan, so again, thank you sa ating sponsors, Davies, kay Sir Chris de Guzman, and then sa ating speaker, which is nawala na ngayon. I think nagkaroon na siya ng internet problem kasi nga kumikidlat ngayon at malakas ang ulan. So again, thank you everyone. Thank you. And for the evaluation form and quiz, ite-text at i-email ko sa inyo na lang. Ayan. So again, Sir Chris, thank you po.
Ayan, thank you rin.
Davies. Ayan, thank you everyone.
Thank you, Ben. Stay safe.
Yes, stay safe there.
Hi, Chris.
Everyone. Okay.